Matter, my lord, the matter for extension of interim order, your
Give.
lordship.
When is it lapsing?
Tomorrow, my lord.
Give.
It is running in the list. Also, yesterday it was running in the list, but due to paucity of time, matter could not be taken up. Item number কত লিখেছেন? লিখে দিচ্ছি।
Number one.
Lordship, in this matter, the records have not been traced, could not be traced. Lordship, I was praying for time because there is also a direction to serve on the respondent, I find. That, and it's not available in Shattak either. So the Lordship, the only alternative is to apply for a certified copy because I have to serve the respondent is also not.
There is an order for service.
Yes, Lordship, prior. It was served on.
Number two.
Lordship, Mr. Image of Biswas will appear in this matter on behalf of the appellant, but due to physical illness, she could not come to the court. Kindly adjourn this matter for 1 week, Lordship.
No, madam, this is too much. We have already recorded that we are not going to give any further. This can't be like this. We have already recorded on 24/6 that with a clear understanding that if she does not appear, we'll proceed. Thereafter, again on the next date, you have got an adjournment. This is no way. 2013 matter, it is being adjourned indefinitely. You get prepared. You go through the brief. You address.
Lordship, his clerk directed.
We don't know. We are not concerned with any clerk or anyone. That is your lookout. You have mentioned you be ready or we'll take it up and we'll record that none appears. This can't go on. Once you file a matter, you are obliged to argue it. Can't make endless adjournments. Go through the record, see what we have ordered. This is not the way. Every day adjournment on some new ground. Call it at 12 p.m. at 12 noon. Whoever has to appear, you tell them. Whoever is the advocate on record, we don't know. Number three.
In this matter, my lord, Mr. Devojyoti Basu is appearing, your lordship. He is on his legs, your lordship. I am only humbly.
You start.
My lord, I am not briefed in this matter, my lord.
Then you why you are
I am
here,
only
sir?
humbly praying for a short
No,
passover,
sorry.
your lordship.
You start.
A very short passover, my lord.
Everybody just wants adjournment. Every matter.
Only short passover, my lord. He is on his legs, my lord, before another division bench, your lordship. I'll just humbly praying for a short passover, my lord.
Who is for the respondent?
My lord, Mr. Tarunjyoti Tiwari is appearing on behalf of the union, my lord.
Where is he?
My lord,
Ask him to come.
he has not able to come today, my lord. Kindly adjourn the matter for a week, my lord. On the next week, my lord, on any day.
Has jointly played list after 4 weeks. Interested then.
My lord,
get
I
it.
was.
Enough for?
In item number 4 also, Lordship, I'll be seeking some more time because the department I mean,
Don't make
Lordship,
such
with the
embarrassing
appeals, what I find.
After the last order, don't make
Yeah,
such an embarrassing
Yeah,
thing,
understood,
please.
Lordship. I was very apprehensive about today because.
No, this is
the
not the way,
department
madam.
is- I had.
Can't go on like this. We
Lordship,
have been repeatedly
because-
telling you, put your house in order.
because, Lordship, I
The
had.
court can't be just like this,
No,
taken for
Lordship,
granted
I
on every day.
understand, Lordship, but what is happening is state appeals are not available in Sharphook, so I can't download them.
Huh?
The state appeals filed by the state are not available. No record.
How long this will go on, madam?
Lordship, I have contacted the department.
So how long this will go on,
They
that
have
we are
asked for
asking you.
time. Because the appeals, the problem.
So this you
I-
can say even after 2 years, if it comes up for the first time.
I won't, Lordship, but this is.
What is this? This is not the way.
This 4 and 5.
Can't
Lordship,
take the court for granted like this.
no, Lordship. 4 and 5, Lordship, I'm suffering the same problem. One, I couldn't trace anything. I had to go.
Is there
for-
any interim order? We'll vacate if there is an interim
Lordship,
order. Take as much as adjournment
Lordship,
as you want.
I'm not aware. Is there any? They can see that.
And both sides are private parties. Why are you?
It's State of West Bengal versus Ganesh Real Estate. That's what I find.
Yeah. There is a contempt also.
I found that from the records.
Are not a person. Hereafter it has become. Not listed. Not listed.
Huh?
Order. It is an order passed from CPAC. After this order, it has become. The CPAC.
আজ তো তুমি আছো মুর্শিদাবাদের একটা মাছ অ্যাপ্লিকেশন Na part mass education extension.
Why it has not been listed? Whatever it is now, it will be before this. Arinam,
Na only. Shall to
the MAT has come out. MAT is of 2019. TPAN is also of 2019. Today again a prayer is made for adjournment. There is a contempt pending that needs to be considered before the DB of which Justice Arindam Mukherjee would be a member.
Item number 5, the officers have informed the date coming to the paper.
Not today,
From Murshidabad, Lordship, the date.
not today.
It's
And number 6 and 7.
Well, in 6, I am for the appellant. Trustee heard this matter on the last occasion. This is regarding my height 169.5.
169.5.
Yes,
Then where is the judgment, Atul Verma judgment?
even already my last occasion. Well, appellant participated in the selection process. He cleared the written examination. Thereafter, my lord, the PET also.
So you are the respondent in the FMA
Yes.
and appellant in MAT. No,
Yes.
you are the respondent in
Your Lordship, in item 6, which is MAT 1348, I am the respondent. And in
966.
966, I am the appellant.
Yes.
And MAT 1348, I am the respondent.
1348.
1348 is his appeal, which has been now made into FMA.
FMA, yes.
Yes.
FMA 1207.
Yes.
Now it is covered by that judgment. Nothing is to be done. Admittedly, is 169.5.
Your Lordship,
Your
We
lordship
have been-
kindly comes to page 47 of the.
No, we are just
Your
want to
Your
ascertain.
Lordship sees the, in which I am the respondent, the order of the Honorable Single Bench, there is no vacancy. So the Honorable Single Bench had dismissed page 68 of the CAN application, Your Lordship, CAN 1 of 2022.
The order starts from page 67.
Yes.
Your Lordship,
May I
the
call your
Honorable
Lordship?
Supreme Court's judgment, the Honorable
She is also appellant in one case. So she,
The Honorable Supreme Court's order that is in SLP 68753 of 2025, which your Lordship is relying on. We have written instructions that the department is filing a review application from
that we have been recording in all the matters. We have been disposing of. You may intend to do whatever you want.
the chart with the
That is
last.
not relevant for us. That's neither for us to consider, nor today we are bound by the judgment.
Lordship, attention to page 43 of the CAN. That is our earlier round of litigation.
We have been recording this submission in all the matters which we have discussed.
Page 43. This is earlier when my lord I was declared disqualified in height and chest measurement.
How, what can be done for a 2018 recruitment process?
Lordship, kindly come to page 44 once.
No, just tell us the law.
No, Lordship.
18 process has concluded.
No,
You want us to pass an order in 26. Just tell us the law.
Lordship, kindly see page 44 once.
We are not, we
Not
don't want,
concluded, not concluded.
we have understood. There was a discrepancy in height and chest measurement.
No, that's-
They could send you back. This time the chest measurement came proper. Your height was lacking in 0.5. We have seen it.
no,
Therefore, we are
it's
asking.
not that, my lord.
It is that, sir.
No, Lordship, kindly come to page 44 once.
You read whatever you want.
Yes. Needless to mention that in the event of petitioner's measurements are found within permissible limits,
Yes.
the authorities may go ahead with the rest of the process of recruitment in accordance with law. This code has been informed by the Learned Council in 2021. My lord. The respondent that the selection process is over and the final list has been published on for 21st January 2021. That time, my lord, amendments were not made. Since the petitioner has been able to make out a case for reconsideration, the authority is likely to act in terms of the opposite. That time, my lord, only select list was prepared. Matter was remanded for.
Again, we are asking you, once a process concluded in the year 22, we should issue a direction in 26. Show us the law. Show us. That's the only thing.
My lord,
Even after reading page 44, the query will remain the same. Therefore, we asked you to address us on this issue.
because my lord, this honorable High Court directed that take further steps in the matter.
Heard, learned advocate
Subsequent
for
page
the
67 order has been passed.
appellant and
all that.
All right, the FMA is dismissed. Yes. Now
Very good.
address on the other one.
Other one is next election. That was allowed.
Where is it?
Lordship.
Your appeal? It is not against the same order.
No,
Your
no,
Lordship, that's a different, again, in a next recruitment, he had given an interview in which
So
Honorable
where is the order in that case?
the Honorable Single Bench's order is at page 79, Your Lordship.
And this order of 29/7/22 passed in 9625 was in FMA 1207.
Your Lordship.
Now where is the other order?
Page 79, Your Lordship. December 11th, 2023 order.
79 of what?
A paper book, Your Lordship, paper book volume 1. In MAT 966 of 2024. The paper book was filed before the FMA number had come.
Page?
Page 79, 11th of December 2023 order.
In that case, you are the appellant.
I
In
was
this
very-
case, you are the appellant.
No, in this guy.
I am
was
the
a
appellant of this and he's the respondent.
Yes. What is wrong with this order?
Your Lordship, in this also our yes that there is no ask for instructions regarding whether there is vacancy for the post of that he had applied presently, and that the review the client has been instructed to file a review from the SLP. The appellants.
We are asking you what is wrong with this judgment, this order of the single judge. You are going to file a review that is hardly relevant today. It's not relevant. So how this is not
Question-
covered?
Because we had preferred, Your Lordship, in this matter, kindly grant me 1 day's time. I'll take instructions
this-
whether there is vacancy or not.
That's not our concern, madam. That's not a plea taken before the writ court. We don't know today.
Your Lordship, because we had preferred the appeal with
We don't know.
there was no
We don't know
delay.
whether for your the petitioner will be made to suffer. There is no such ground taken in the order passed by the writ court, and that ground which has been which the writ court has considered is already allowed by the apex court. There is no question of any argument on this.
Your Lordship, 1 day's accommodation. Mr. Ajit Mishra is leading me in this matter. He wanted to cite some judgment before Your Lordship on
What judgment after Atul Verma's judgment? What judgment he will cite?
Lordship, one,
Please tell us.
it may be passed over at 2 p.m. if it could be taken up at least.
There's nothing in this matter. This
I got
Number 8 and 9.
Lordship, 8 and 9, Lordship. Lordship, in item number, I have put the record to item number 9. Lordship, there is an application, there is a CANS for application under order 41 rule 27.
Hmm?
Give an affidavit.
There is.
An application for additional documents, Lordship, CAN for. I have the papers of 9, Lordship. It arises out of the same judgment.
This is interconnected
If
matter.
both are interconnected, Lordship, there is an application filed by the respondents for additional documents. Lordship, which is scanned for in item number 9.
What do you want?
Lordship, I need to rely on an affidavit.
In respect to which can?
Scan for in respect of 9, Lordship, I don't have the records away. They should be, I'm expecting the records today, they'll be coming, but 9, my learned friends have given me the records.
Who is appearing in it?
Lot 8 and 9.
Here, I mean,
the part
state
of
Lordship, I ulto hai gacha. This is state appeal. Lordship.
They have preferred that.
We are
Oh, that is your appeal.
Yes, ma'am.
no, the appeal. Ulto hai gacha.
Then what are you waiting for? We are unable to understand this lackadaisical attitude.
Lordship, it is
What are you waiting for? Repeated adjournments.
I
It's
know.
not the first time.
Lordship, it's not. Lordship, but now at least there is some, I mean, they have responded now. They've asked.
Oh, they have done us a very big favor.
I understand, Lordship. I
What are
understand.
you submitting? How are we concerned whether there is,
No,
if your client doesn't respond?
I understand.
How are we
Lordship, but this
concerned?
is the
The proceedings
that
can't
we
be
are
held up.
facing, Lordship.
Every case cannot be held up because
No.
your client is not responding.
And the main problem is state appeals. I don't get it from Shattok. That is
That is your problem, madam.
Understand.
It's not his
These are
problem.
the-
It is not our problem.
I agree.
And there has to be a limit to the patience which you expect from the court.
Lordship, I agree to that.
This is the third adjournment you are seeking on this
Some
ground
response from
in the last 2 months.
yes, Lordship. I agree.
An unfortunate pair is again made today.
Lordship, and
I can enrich the legal aid, take as much adjournment as you want.
Lordship, I should tell. Lordship, in item number 9, there is a CAN filed by my learned friends, Lordship.
That was long back. We remember this matter. That was long back.
Because, yes,
That
Lordship,
was
I
maybe 6 months back,
maybe that.
or if not more.
But
Today you want to say that you want to file a reply and this and that. You do whatever you want. Both matters are adjourned 3 weeks. Don't allow your clients to bring that administration.
Number 10.
Grateful learn.
The writ court order is of 24/4/2015. 24/4/2015. The writ court's order.
But the petitioner before your lordship is applied for the career advancement scheme on the basis of a circular issued by the government and thereafter the University of the Krishi Vishwavidhyalaya. Self-appraisal scheme, Lord, the lordship will get that application at page 34 of the paper.
What was your prayer in 1549? WP 1549?
1549.
Yes.
Page 29, Lord. It is a benefit of career advancement promotion scheme by allowing him to higher scale of 16,400 to 22,400 with effect from February 2002. This was the prayer.
This is 1549. Yes.
But on the basis of this circular, the petitioner applied for. Lord, that
On the basis of which circular?
for page 34, Lord, kindly come to page 34.
And when did he retire?
2004 January.
What is the date?
Date of retirement is January 31st January 2004.
Or your claim was considered?
Lord, it says in the report it was not considered. But sometimes says that it was kept in the sealed cover because of pendency of two earlier writ petitions. Lord,
We are asking you, did you make such a claim before the authorities before rushing to the writ court?
yes.
Where is that claim?
Lord, your lordship, kindly. Lord, the letter addressed to the Vice Chancellor. It Page 70. Lord, can you come to page 70 of the paper?
70.
70.
What interview? What interview you are talking about?
Lord, that is the career advancement scheme.
That is dependent on an interview.
No interview was necessary. They have said that interview has been taken, called for interview, but simply on the basis of the papers, they will consider. And about the selection committee, so far the selection committee, it appears from their own admission, they have not considered it in view of pendency of two earlier writ petitions, which ultimately became infructuous because they took no action, and the petitioner is eligible for the said benefit.
No, when you have objected that you are not required to appear for the interview. Where is your objection?
No, we have not objected.
Don't make such submission. You were asked for appearing at an interview.
Yes,
You participated in the interview. All others participated. Their name was published. Your name was not published.
Yes.
Now you are saying there was no requirement of interview. How can you say that? They have filed an opposition here.
Yes, they filed opposition, they filed here before the appeal court, they have not filed. In the writ court, they
No,
filed.
no, the writ court opposition will suffice.
And will kindly see the documents. From page 51 to 58. Page 36, your lordship can see the scope and what is the qualification and how it can be determined. Page 36. Last item, paragraph 3.
So apart from this case, which case is pending today?
But two other cases were there, earlier cases. In 1993, a writ petition was filed challenging Lord an order of suspension. This Honorable Court stayed that order. Ultimately, he was allowed to join, and Lord, thereafter his increment was granted. And Lord, ultimately, the university authority asked him to take classes, though he was an electrical engineer.
We are again asking you,
My lord.
which matter apart from this 1549 is pending today?
That was not two other writ petitions.
Which matter apart from this writ petition is pending today?
Those were all, Lord,
All disposed of.
by the same order.
So therefore, now there is no impediment that
No
they will
Yes.
open the seal cover
Yes.
and take whatever they have to do, they will have to do. Since it has been stated in the opposition, and it is your case also, that the sealed cover is not being opened.
Right.
Now it is only for them to do it. Where is the question of this court looking into anything? Whatever may be the result of the sealed cover, they will have to implement
But
it.
during hearing, they produced the seal cover
Yes,
before this Honorable Court,
yes.
and it was open. Lord, that was not supplied to us, but Lord, the learned trial judge has recorded it. Your Lordship will get it from the order impugned.
Where is the order?
Lord, Your Lordship can see at page 169. Lord, question of shield cover didn't arise at all. It is a Lord ploy.
That you cannot say today.
Lord, yes, because Lord, your Lordship knows
That you cannot say today.
shield cover procedure is followed when a suspension order is there, or Lord, there is a disciplinary proceeding.
No, suspension order is not sufficient unless a charge memo is issued.
Nothing was done.
We don't know. That's not before us.
So it is before your Lordship.
No, it is not. You are only seeking career advancement.
Lord, in the earlier two writ petitions,
We are not going to look into that. We have already recorded in one order that this is the only writ petition pending. We are not going to travel beyond that order today.
Lord,
You know very well it has been recorded by this court in an earlier order that apart from 1549, nothing remains. We are not going to open those issues again.
Lord,
So there is a pending proceeding which is admitted by you in your writ petition. You
Yes.
say that because of pendency have not been given. So they will now look into it.
Sir, they said, I have never said.
You have said in your writ petition.
Lord, on the
we'll
basis
show you.
of their statement,
So that is an admitted position.
not admitted, Lord, we disputed it. Well, also kindly see, they for the first time let us know.
In this writ petition, where is this issue taken by you? Come to 1549. Where in your writ petition have you challenged the fact that there is no pendency of proceeding?
At the relevant time,
This is not an open forum to say everything for your career for the last so many decades. This is not an open forum. Your specific claim in the writ petition is, I have participated in a scrutiny for grant of benefit of career advancement. That result has been kept in sealed cover because there is a proceeding pending. They also say in their opposition.
no, it is not our case. So I was given to understand that my case has been.
Then let us see what you have said in the writ petition. Come to your writ petition.
Lord, kindly see.
Yes.
Did not equal. Lord, page 21. Paragraph 16 and 17, my Lord, kindly see. It was the Vice Chancellor who gave me understand that your case has been put in seal cover.
So that's not an issue here.
Yes.
That is not an issue here. Your only issue is grant of SCP. That action is not impugned in the present writ petition. We will not allow you to raise that issue.
But that
Your only claim is grant me SAP.
Yes.
Why it has not been granted despite the fact that I participated in the scrutiny? This is your case.
I have participated. I have
Despite
all
that, all other persons' result has been declared, mine has not been declared.
Yes.
This is your grievance. They have come out in opposition to say that because there was pendency of this writ proceeding, the executive committee decided that we will not open it. Now, or therefore, we asked you. Now, since there is no writ petition pending, there is no impediment.
Lord, your Lordship, that is, it is totally malafied. Your Lordship, kindly see there are there.
That is not a case here. There is no issue of malafide to be examined here in this case.
Lord, kindly
It's
see.
not an open forum that you can raise everything. There is a limited prayer. Come to your prayer again. What is your prayer? Read your prayer.
Lord, to grant
That does not mean you can raise anything and everything.
to higher scale of pay such and such with effect
Yes.
from February 22 on the basis of that scheme.
Correct.
Lord, kindly see what was the scope of that scheme. Your Lordship kindly come to page.
Who is saying you're not covered by the scheme? That's not
Lord, and Lord,
that's not
fulfilled all conditions.
we don't know.
And Lord, kindly see there
We don't know.
in writing what they have annexed. Lord, kindly see once what is their stand. They said that your case has not been considered. Question of shield cover didn't arise, but subsequently they made out a case that shield cover is there.
That issue, whether it is to be resorted to or not, is not in the present case. There is no such issue in the present case. You have seen the Executive Council's resolution, which they have relied upon. What they have said. Therefore, we asked you if there is no proceeding pending. There is 177th meeting of the Executive Council was held
Yes.
on
Kindly come to
20th
page 84.
on 20th June 2003.
Page 24.
Page
24. 84.
yes. Was not considered
Not considered at all.
because the pendency, now there is no pendency, they will consider. That's what we are saying. What is there left for this court to do?
Then Lord, your Lordship kindly direct them to consider.
No, what the Honorable Single Judge has said about this, that we are trying to see, about this, why it has not been paid. Where is that finding? That's why we asked you.
Lord, there are so many irregularities, and he said that I have not fulfilled the condition because continuous 8 years, continuous 35 years service I have done, and in the same post, my
Where the Single Judge has considered the result in the sealed cover.
Lord, your Lordship kindly come to page 170. It is page 156 onwards, Lord.
You said the Single Judge has considered the report in the sealed cover.
Yes.
We are asking you to point out from the judgment where he has considered.
Page 169. Here, Lord, sealed cover was opened before the learned judge.
169.
169. Impugned judge.
Yes.
The matter was placed before the Lord Executive Council.
So it was turned down.
Yes.
The sealed cover has been opened, it was turned down.
Yes.
Yes.
But there is no reason, Lord. There is how it was turned down.
Whatever
That's
it
why
is.
I am telling, Lord, kindly see the scope of the circular.
When you challenged this finding of the sealed cover, when did you challenge it?
No scope, Lord. This is the disposed of by this.
Correct, correct. So now it is, to your knowledge, did you challenge this?
After, Lord, this order was passed, I preferred appeal before your Lordship.
Therefore, we are saying what when this, unless this is put to challenge, can you get anything in any court? Tell us.
But Lord, it appears that the decision itself of the committee is.
There is no question of appearance. There is no question of appearance.
Now,
There is a
Lord,
question of putting to challenge an order which adversely affects you.
which
Unless you,
in the self-same proceeding, Lord, by supplementary affidavit.
where is that? Show us where you have challenged this.
Your Lordship will get the supplementary affidavit.
Yes. By way of supplementary affidavit, an order can
Lord,
be
it was
challenged.
given liberty to file supplementary affidavit when the sealed cover was opened before the court.
Yes.
Your Lordship, kindly see, this is the supplementary affidavit filed by the petitioner before this honorable court. At page 97, Lord. Can you take note page 99? It starts paragraph 5. Details and ultimately Lord claim that it is not. It has been challenged.
Yes, where is, from your supplementary affidavit, show where you have challenged the decision. Where is your supplementary affidavit?
So supplementary affidavit is page, it starts at page 97.
Where is the challenge to the 177th Executive Council's resolution?
Kindly see this.
Yes.
Uh, paragraph 6 onwards.
Just read where you have challenged
Yes.
the order of 177th Executive Council resolution.
Made this submission before this Honorable Court on 19 May 2004, pointing out that the said remark is totally inconsistent, or that is the remark of the sealed cover. Page paragraph 6.
Paragraph
Paragraph 6. Lord, it starts
of the supplementary.
supplementary. Lord, your Lordship kindly come to page 99, paragraph 5. That after change of determination, the matter appeared before the Honorable Justice Indira Banerjee on 7th May 2004 at 2 p.m. with a direction upon the Learned Council of the University of the to produce the sealed cover before this Honorable Court, containing the result of the petitioner in view of submission on behalf of the university that the result of the petitioner has been kept in sealed cover. On 14th May 2004, the sealed cover was furnished and this Honorable Court got the same opened, and it was found that simply by 2 words, the committee has endorsed in the remarks column, not recommended. I was very much shocked in view of such remark of the standing committee or selection committee, as the same does not represent the real state of affairs. According to me, the said remark is a manipulated one without any basis. No score sheet was produced, and in fact, the said remark is an outcome of some arbitrary, illegal, and discriminatory action on the part of the authority. It is very curious that the standing committee has failed to assign any cogent reason for such non-recommendation, and there is no basis at all to justify their so-called non-recommendation. That my learned counsel made this submission before the Honorable Court on 19th May, pointing out that the said remark is totally inconsistent with the act on the part of some of the members of the selection committee. The selection committee has, in deviation of the guideline specifically provided in the notification of scheme, acted whimsically. It was also pointed out that some officers who have not fulfilled the eligibility criteria as provided in the said notification have been showered the benefit of the said scheme by the committee for obvious reasons. It was further pointed out that that recommendation for promotion or career advancement must be within the parameter of the notification, and there is a scope. There is no scope as for any discretion on the part of this selection committee. It was further pointed out that though my academic qualification and performance in all respects being much superior to other officers who have been blessed with the benefit of the said scheme, but unfortunately I have been denied the same without assigning any reason whatsoever. Admittedly, on the basis of the self-appraisal report, this screening committee recommended my case. My learned counsel sought for leave to file a supplementary affidavit for bringing the notice of this honorable court, the arbitrariness and malafide on the part of the university authorities with supporting documents in order to lift the veil and do justice. That this honorable court, upon considering the aforesaid submissions and prayer made on my behalf, has been pleased to grant me leave to file this supplementary affidavit by order dated 19th May 2004, which I hereby do. While granting me such leave, considering the fact that I have retired on 30th January 2004 and not been paid anything towards my retirement benefits, His Lordship was gracious enough to direct the university to pay my retirement benefits within a period of 4 weeks from the date without prejudice to the rights and contention of the parties. That has already indicated, the power, function and role of the standing committee has been defined in clear terms in GO number such and such dated 3rd March 2002, from which it clearly appears that the procedure to be followed by the committee is not for the purpose of selecting one or two candidates from amongst many for filling up specific vacancies, but to assess as to whether the existing officer of Vishwavidyalaya is approved post under approved scale are eligible to get the benefit by fulfilling the conditions provided in the said notification on the basis of their self-appraisal report. There is no scope for judging performance of a candidate in the interview as illegally and arbitrarily observed in the report of the committee regarding my candidature produced before this honorable court. That in the notification issued by the Vice Chancellor in clear and unambiguous terms, it has been stipulated that the career advancement or promotion under the said scheme would be settled and offered only upon the strict compliance with the said government order by following the guidelines indicated therein. The university authority or the selection committee has simply exercised their discretion in such a manner which indicates that as if they have uncontrolled and unfettered power in the matter of allowing benefit of career advancement or promotion to the officers according to their whims and choice. I am furnishing herewith a comparative chart regarding biodata and of the officers who have been extended the career advancement or promotion and on myself, which will show the manner in which committee and or authority have acted. The said chart is annexed here to Master Sajan. It is apparent from the said chart that the standing committee recommended those officers who do not fulfill the essential conditions for getting the benefit, but did not recommend me, in spite of the fact that I have fulfilled all the conditions in a far superior manner to the others shown in the said comparative chart. That it will appear that I am the only candidate amongst all who have received a national level award for research work. I am the only officer in the university to have performed 16 years teaching at the university level, presented a number of papers in various seminars and workshops, and contributed in the academic field by establishing a full-fledged electrical laboratory in the university. I possess the highest training in computer amongst all officers of the university. But unfortunately, in spite of my...
You expect the Red Court to sit in appeal and consider all these aspects regarding your suitability over the decision of the committee?
Lord, that is not your also can see the circular and what they have
We
done.
have not challenged the executive
But
assembly.
in this manner, there was no scope.
So this much is there.
Yes.
This we will see.
Yes.
Whether we can sit in appeal, whether the Red Court should have sit in appeal over the subjective satisfaction of the
Lord,
authority concerning conducting the scrutiny, that we will consider. We have not yet seen any challenge to that decision.
Lord, your lordship, kindly that you have challenged in this supplementary affidavit,
This we have seen.
specific
We have
manner,
gone through.
there was no scope because on the basis of this.
All right, so we'll record that you did not challenge because there is no scope.
No, not only that.
That will
No,
record.
at the relevant time, this is the challenge. By
All right.
supplementary affidavit, this is the
All
challenge.
right, that we have got it. How many times you will say that?
And
We
not
have seen
simply
it.
see once.
Yes.
Kindly look into
You are the best person according to you. We have seen the entire supplementary. There is nobody better than you. All the three persons, they were inferior to you. You have made specific allegations. They did not fulfill this. They did not fulfill. By name, you have made allegations. They are not parties before the Red Court. You are asking the Red Court to consider that you are superior to those three persons, and therefore the executive, the scrutiny committee has fallen in grave error. You have understood.
Lord, that is another thing. Lord, that is another aspect.
That is the only thing. That's not another thing. That's the only thing. In
Other aspect
supplementary.
is that, Lord, kindly see. That's why I'm repeatedly, Lord, requesting your lordship to see the scheme. What is the scope?
There is no challenge. There is no scope.
Lord,
for
that
looking
said
at
that
it.
they have not done.
You,
In accordance with the scheme.
see, you are,
That is the challenge, Lord, I have said
that by now it is very well settled how an order is to be challenged.
Yes. My lord,
If
you'll-
there is an order and that order is taken into consideration in a proceeding where you are a party and that order is shown to you, are you required to put it to challenge if you are aggrieved or you are not required to put
Lord,
it?
I am aggrieved by the action of the university and I have just appointed
Okay,
apart
we
from
will consider this,
all other things.
that all this will
And
consider.
Lord, kindly see the learned trial judge.
Yes.
He has said, Lord, kindly see that I have not fulfilled the criteria. I have not in continuous 8 years service in that post. I am continuous 35 years of service in
That's why we are saying, do you expect the writ court to examine all these issues and give a finding regarding the suitability of your service? Is it the domain of a judicial review? Tell us.
Judicial review, Lordship, in some cases, Lord, I
Yes.
cite one judgment of this honorable
Yes.
commission bench, Lord, presided over by Honorable Justice Satyabrat Sinha.
Yes, give us.
When,
Yes.
when
Yes.
Lordship can Yes. So kindly see these judgments.
Yes, please give.
The scope of judicial review, Lord, kindly see this is held at page 22. Lord, your Lordship knows, Lord, this. Here in this case, Lord, this principle will apply.
Yes, which paragraph you are relying?
Lord, your Lordship, kindly come to page 122. Held.
Yes. That we have read. That we have already read. That last paragraph at 122.
Yes.
That we have seen. Anything, what you want to point out, we are asking you.
Here it has been held that judicial review, power of judicial review, where here I have pointed out that according to the scheme,
Please read, please read.
yes, the order which was passed on occasion without considering the fact in issue could not be said to be an order which was binding on us. It is true that this court is in exercise of its power of judicial review, exercised on limited jurisdiction. It can interfere only when the decision of the administrative body suffer from illegality, irrationality, or procedural irregularity.
Correct.
It is also true that this court cannot sit in appeal for the decision of a selection committee, but that does not mean
Yes.
that does not mean that the court would shut its eyes despite availability of bare facts on record of the
Yes.
case.
Very well.
Although this court would not interfere selection process, but can verify whether fair consideration at the hand of selection committee has been made or
Yes.
not, and the selection should be fair and should not suffer for arbitrary,
Very well.
nor the same should be capricious or fanciful. If a glaring injustice or non-fulfillment of the requirement of fair play is brought to the notice of the court may act so as to complete justice to the parties. Lord, here also, Lord,
Sir, in that case which you are relying upon,
Yes.
the authority who considered he did not have the authority to do so. He was lacking in jurisdiction. Yes, any other judgment?
Lord, here, Lordship, can you see here,
Come to the next paragraph. Just read the next paragraph.
the additional district inspector of schools was not authorized.
Yes, now the judgment you want to show.
Lord, this is here in this case, but general principle has been quoted.
You have read it, we have heard it.
Yes, Lord,
Any other case?
just
we
I
are
am pointing out, Lord.
Yes.
I have, Lord, pointed out from the readings that this has been done.
Yes, you read it. We have heard it. The entire pleading you have read.
Selection
Any
committee
other
has
judgment
done
we are
in
asking?
accordance with this procedure
Correct.
and guideline.
Correct.
So kindly, that's why, Lord, I am telling your Lordship, kindly once see the guideline, what is to be followed for the purpose of granting this. Lord, kindly once.
See, we have not found a challenge to the order. We are being very clear in our observation. We gave you an opportunity to show whether you have challenged it. You have not challenged it. You have raised an issue that the three persons who were allowed, they were inferior to you.
Not only that.
And they did not fulfill the requirement.
Well, not only
You
that.
were superior to them. You got an all India award. This, that, everything.
Not only
That
that.
is the only thing you
No, not only that.
Yes.
Your Lordship, kindly see that. That's why I am said. Lord, your Lordship, once more kindly see the scheme and what is the scope.
Why? There is no challenge.
I have challenged.
We have not seen any.
This discrimination, I have challenged that.
You have not challenged, sir. That is not the way to challenge the document.
Lord, kindly see the supplementary affidavit.
We have gone through the entire supplementary activity. You have also read so many paragraphs.
Your Lordship, kindly,
Reading it twice will not improve the situation.
Lord, kindly see once. Your Lordship, before that.
Unless an order is, see, the law of pleading in a writ petition is by now settled law. It is not a pleading in a civil suit. There has to be a clear and definite pleading backed by annexures in support of the governments. Unless you set out a challenge to an order, it is not open for the court to go into it. It would be unfair to the other party.
Lord, I have only.
You can't say that those are unfair, those persons are inferior to me, therefore,
Ignored.
that we will consider.
Kindly ignore that.
We'll
That
consider
part.
that.
Kindly ignore that part.
We'll
Your Lordship, kindly see, here I have said, the power, function and role of the standing committee has been defined in clear terms in the GO. What they have done, in my case, whether they have fulfilled those conditions or not, that is one of the part of challenge.
Yes.
Lord, kindly see this, followed here, not followed. It is clear, it clearly appears that the procedure to be followed by the committee is not for the purpose of selecting one or two candidates from amongst many for filling up the specific vacancies, but to assess as to whether existing officer of the Vishwavidyalaya is approved under approved scale are eligible to get the benefit by fulfilling the conditions.
Correct. That's what we are saying. You have challenged eligibility.
Not
Any other judgment, please show which other judgment you are relying on.
Lord, other judgment is regarding Lord the seal
So,
cover,
give-
regarding seal cover formula. Lord, here your Lordship knows.
You are relying on Janki Raman's case.
Lord?
Janki Raman's case.
Janki Raman's case I have brought.
Very well.
Lord,
Any other judgment?
subsequent also. Lord, what happens here? Their allegation is that.
Give us the Janki Raman citation, yes. So sealed cover procedure cannot be resorted to unless there is a charge memo. In contemplation of
Yes,
proceeding, it cannot be done.
Yes, here nothing.
All right. Anything else, please?
Here nothing is not Janki Raman have brought. Your
Yes.
Lordship knows, and here Lord, I have stated that the very procedure they have not followed
Yes.
according to the guideline of the circular itself.
Yes.
That is the main challenge.
But you have already said, we have taken note of that. You need not repeat it so many times. Yes. We are asking you to move forward. If there is anything else,
Lord,
please tell us.
Lord, from the communication, it will appear that committee has not at all considered. Not considered and said subsequently said that
Then
it's
we
sealed
take
cover.
it that there is nothing else. Now you are repeating the same thing twice and thrice. So
No,
then
no,
we
your
take it
Lordship
there is
has-
nothing else.
So that document your Lordship has not seen. Your Lordship kindly see here. Yes. But what is career announcement? An officer, such and such, he has.
You are reading which page?
Not page 34, the
Page?
page 34
Yes. Of?
of the paper book. This is the circular.
This you placed at the very outset. Now you are repeating. That's what we are saying. We have already gone through this.
Lord, kindly see.
We have already read it with you at the very outset when when you started your submission. You started with this document. We are asking you if there is anything else. For that we are waiting. If not, then we'll consider all this. Don't worry.
I'm not here. Your Lordship said that it has been held that the executive has not at all considered it.
Very well.
Therefore, no question of seal cover they have introduced. This is also a bona fide purpose, and this seal cover procedure is not applicable in the present case because in 93, a suspension order was passed. It was challenged before the court. It was stayed instantly, and thereafter, everything has been withdrawn, and ultimately, by the impugned judgment, all the writ petitions were disposed of.
Very well.
And they admitted that there is no allegation against the petitioner before your
So your submissions are in substance that there was no occasion for a sealed cover proceeding. You have not been considered. The others have wrongly been granted, and the circular under which you are claiming has not been complied with.
And that is not another thing, Lord, that seal cover procedure.
You already said that it cannot be because there is no charge memo. That
Yes.
is your submission.
Yes.
Heard the learned advocate for the Yes. Only.
First of all, matter item number 2.
For the petitioner, my lord. My lord, section 5 application, my lord, already filed, my lord. 192 delay, my lord. Kindly, my lord, restore the application, my lord. We'll fix the date for hearing, my lord.
There is a delay. What did you say? There is a delay.
Delay 192 dates.
Which can?
Can 2, my lord.
There is no can. Check.
তাই লেখা আছে
So this is delay in filing the restoration.
Yes, my lord.
Look, come to the restoration. No condonation petition is required. It's a right. It is in a writ proceeding.
Sorry, my lord.
It's in a writ proceeding.
Read proceedings, my lord.
Then where is the question of limitation act applies?
Limitation, my lord.
All right, you come to the restoration. This is a
But I'm
question of
led by my
limitation
lord
act
Indranil Vishwas, my lord.
applying in a writ proceeding.
My lord, I am led by Mr. Indranil Vishwas, my lord, due to his kidney problem.
Let us see what is the reason that you have
Kindly, my lord,
stated.
consider, my lord, and fixed a date for hearing, my lord, on Monday, my lord.
Yes, so this we are allowing. Come to the merits.
Kindly fix a date for hearing, my lord, on Monday, my lord.
This is arising out of tribunal's order.
Yes, my lord. Yes, my lord. WPST.
Before the case in. Same. Yes, we have gone through it. What is your submission? What is wrong with the order of the tribunal?
My lord, I am led by Mr. Indroit বিশ্বাস. my
Okay,
lord.
no question of adjournment.
Kindly,
Don't
my
make
lord.
such clear.
Kindly,
No question of adjournment. Your cup of accommodation is full. We have already told the learned advocate who had appeared in the morning. This can't go on forever.
my lord, petitioner, my
This
lord.
writ petition is of which year, sir?
My lord, no petition, my lord.
Then you should not have been here. We said either someone should come and assist or we'll dismiss in default.
Kindly, my lord. This is my last
No.
time, my lord. My lord, I am approaching before your lordship, my lord. Kindly.
You come and show us what is wrong with the order. You have relied upon these documents. We have seen the documents. There is a host of documents which you have shown to suggest that you were in an ad hoc employee entitled to some consideration. These are the documents. All the documents, which one you are relying upon, we don't know, but they are all the same. All are identity card issued by an outsourcing agency. Either the agency's name is X in one card and Y in another card. Based on such identity card, the tribunal said there is no question of considering that you were ever an ad hoc or casual employee. And that you have challenged. The order of the tribunal is of 2013. We are in 26, in between at least 5, 6, 7 adjournments. We don't know what you are expecting to get for your client today.
But I agree, my lord, but
No, sir. These matters we cannot allow to be
also, my
kept.
lord, not sir, my lord.
You are advocate on record.
My lord,
We don't require any service on anyone.
no, my lord.
We don't require any service. You make out a case, we direct. If you don't, we'll dismiss it. We don't require any service. If we want to interfere, we will ask them to. Tell us.
No,
What do you expect today? Tell us, after this rejection in 2013, after 13 years, you have challenged the advertisement taken out for contractual employment in 2013, even prior thereto. And this you have kept pending for more than a decade only by seeking adjournments. Only. There is nothing here but adjournment.
This is
Please have a look.
my lord, as per
Please have a look, sir. Please have a look.
this
Look
is
at the order
transfer bill,
sheet.
my lord. So, my lord, I cannot.
Any order other than adjournment, just have a look. Once dismissed in default, thereafter restoration filed, only adjournments. What are you doing for your client? We don't know. We don't want to say anything.
This is transfer with my lord.
Sorry.
My lord,
You are the record that you have refused to make submissions.
my lord, kindly, my lord.
Yes. Give your
My lord,
appearance.
I'm not an advocate on record, my lord.
Then why you are here?
My lord, Lanet,
No.
my lord.
Then we'll record that there is none to represent.
Kidney problem, he is unable to.
None
appear.
appears.
That's why, my lord, I am, my lord, appearing.
On
my lord.
behalf
Item number 11.
Question application will be allowed or
No.
লাভ করতে হবে রিট পিটিশনের
Yes.
a petitioner before your lordship was an head cashier of United Bank of India. It's now merged with Punjab National Bank and it's a Punjab National Bank. While he was in service in 2018, 17 November 2018, a charge sheet was issued against him. Mainly on the threefold count. Three charges were against him. Firstly, he has taken rupees 3 lakhs from the locker and ultimately he returned back. First charge. Second charge, he has taken money from the bank agent in lieu of gratification for loans. And thirdly, he has taken money some other person to give him the job. Three allegations was leveled against him. Now the charge sheet was issued, documents was supplied to me. I replied to the charge sheet. Now the inquiry process was conducted. But during inquiry process, once document was produced at the time of inquiry by the departmental lordship, the representative, which was taken, considered, and on the basis of that document, inquiry officer filed his report. Subsequently, I replied to the inquiry report. Final order of punishment has been passed and order was removed from service with superannuation benefit and without any disqualification of further service. I preferred an appeal. On the threefold ground, I preferred an appeal. Firstly, on the ground that the document which was the punishment based on the particular document or the inquiry based on a particular document was never served upon me. I never gone into that document. I never seen the document. Firstly. Secondly, the double jeopardy I have taken the second lordship, the ground in the appeal. However, the appeal court,
Double jeopardy applies in a departmental proceeding.
yes, here applies. I'll show to your lordship. Normally, the
No,
department.
whether that, what is the law? The doctrine of
here
double
depart-
jeopardy applies in a departmental proceeding.
In this case, the rule says if a particular person or employee has been punished by a particular charges, he cannot be charged again on the same cause of action. That is the rules. Rules itself says.
There is a second charge memo
second charge memo.
for the same offense.
Same office. That is my case. Same office. I'll show it to your lordship.
Let us see the two charge memo. Where are the two charge memo? Let us
Let me first show me the charge sheet which was issued against me.
correct. So we have to see two charge memo.
Yes.
Let us see where are
First
the
one, page 95. The charge sheet which is impugned today. Page 95. Got it? May I read for your lordship? On 15/2/2018, you had misappropriated rupees 3 lakhs from the cash department. At
this is the earlier one or the latter one?
Latter one. I'll show the earlier one thereafter. A cash shortage of rupees 3 lakh was found by the branch manager. The joint custodian of cash, while undertaking the cash verification of closing cash on 15/2/2018, the branch manager found difference of the said amount in physical cash while verifying with the safe guide register. You have confessed to have taken away the cash from branch for self-use to meet the expenses of treatment of some kidney-related ailments of your son, and also you had borrowed a large sum of money from outside. On being asked, you made good the shortage of rupees 3 lakh within 30 to 35 minutes. Thus, you have allegedly committed a fraud to bank treasurer to extend of rupees 3 lakhs for your personal gain and purpose. The second, this is the charges which was leveled against me earlier. During the tenure of your service as sub-staff of Brajavallabhpur branch from 7/8/2014 to 26/5/2017, you have committed the following irregularities. You have accepted bribe of rupees 7,000 on 15/12/2016 from a customer, Sri Aurobindo Pal, for facilitating a loan for him, which you had confessed, and the amount so taken was returned by you by creating the amount crediting the amount of Sri Pal on 19/1/2017. Second, you have taken money from 3 BC agents with a promise to arrange government bank's job for them as handed over stamp paper to this effect to 3 BC agent complainant. Thus, you were found to be indulged in illegal fraudulent activities and duped the 3 BC agent of the branch. Your above act, which is unbecoming of an employee of the bank, has tarnished the image of the bank. Thus, you have fraudulently acted
Where is-
giving the
Yes, where is the earlier
Yes,
charge?
earlier is that page 158.
What is the date of that charge? 150.
It is dated 35 May 2017. Says the above customer of Brojoballapur branch has made a serious complaint against you that you, while posted at our Brojoballapur branch, had illegally taken a sum of rupees 7,000 and Xerox copy of KYC document, Sri Aurobindo Pal of village so-and-so, in consideration of arranging sanction of his loan for rupees 1 lakh for the end of Brojoballapur branch. You are advised to submit your stand in the above matter within 7 days from the date of receipt of this.
So this is the
letter.
charge memo.
Right. Now, thereafter the inquiry report.
158 is the charge memo.
Yes. 159 is the inquiry report. As report of the inquiry in respect of the complaint of Sri Aurobindo Pal against Sri Pratul Kumar Nayak, the then sub-staff of Brojoballapur branch. This is the inquiry report, and ultimately the finding is at page 160.
Yes.
Observing and recommendation. Taking all the above fact, my observation is that Sri Aurobindo Pal has given money along with KYC documents to Pratul Kumar Nayak for
164.
160. 159 start inquiry report. It's end with 160. Can you see the observation and recommendation? Taking all the above facts, and my observation is that Sri Aurobindo Pal has given money along with KYC document Sri Pratul Kumar Nayak for airing of in sanction of a loan to him. Two, Sri Pratul Kumar Nayak has confessed for receiving money and document from Sri Aurobindo Pal and has deposited back the amount in the account of Sri Pal. The branch manager of Sri Bhola manager Sri so-and-so in his letter dated 4th January 2017 reported to the CRM Purva Medinapur region that Sri Pratul.
Very well. So you say this is the second. Anything else?
Kind is the now next the punishment order. It's a minor punishment has been given.
When?
Page 161, 22/12/2017.
What is the date?
22/12/2017. 22nd
17.
December. 161.
Page?
161. Kindly see the last line. Your such type of dubious activities has been taken by the competent authority very seriously, and you are warned to refrain from such activities in future. As per the minor penalties.
Warning is a minor penalty.
Yes.
Please show. Where is that? This is which bank? Union Bank, United Bank.
Now it's merged with Punjab National Bank. It was initially United Bank. Now it's merged with Punjab. But kindly see the minor penalties. That is.
No, this is conduct is under which procedure?
But it's conducted under bipartite settlement.
Yes, bipartite settlement of 10-4.
10-4. But kindly come to page 12(8). An employee found guilty of minor misconduct may be warned or seizured.
Which clause you are reading?
Clause 8, subclause A, page 12.
Yes.
Number, kindly see the clause 9. A workman found guilty of misconduct, whether gross or minor, shall not be given more than one punishment in respect of any one charges. In my respectful submission, my lord, while issuing the second charge sheet, this has been not considered. My lord, honorable single bench, while considering these aspect, my lord, if you also kindly see what the honorable single bench has considered regarding this aspect. My lord, kindly come to page 247.
Can you give us the internal page of the Honorable Single Judge? Order?
I'm saying the application. In the application, I have annexed.
Can you give us the internal
Yes,
page?
yes.
Yes.
Let us start from page 10. Regarding double jeopardy,
It's not a case of double jeopardy. It is a case where once a charge has already been taken to its consequence, whether a charge memo can be issued on the same charge again.
yes, my lord, I may be corrected.
Where is this point raised by you? Where was it considered?
My lord, I'm showing to you, lordship. My lord, kindly come to my lord, may just but paragraph 16, not in internal page 8, internal page 8. Paragraph 16, 17. Well, may I read for your lordship? Let me consider whether the decision of the concerned authority is unreasonable, perverse, or illegal in respect of fact and circumstances of this case. Right, memo dated 22/12/2017. It appears that one inquiry was conducted by senior manager admin Purbo Midnapur region in respect of a complaint of a customer, namely Aurobindo Pal, against petitioner for taking ₹7,000 illegally in consideration of arranging sanction loan. On the basis of such inquiry, Chief Manager Admin has cautioned the petitioner by memo number 22/12/2017. The above mentioned memo issued by Chief Manager Admin does not reflect the fact that any departmental proceedings had ever been initiated against the petitioner for alleged complaint by one customer, namely Aurobindo Pal. It is the contention of the appellate authority that Chief Manager Admin Purbo Midnapur region has issued the memo in his administrative capacity. The term double jeopardy means imposition of punishment twice upon a convict for similar offence. The alleged illegality by the petitioner reflected in the complaint of a customer, namely Aurobindo Pal, never placed before any disciplinary authority. Moreover, petitioner was never asked to submit his explanation, defense against such complaint. Thus, memo dated so and so cannot be said to be a punishment or caution censured by the petition.
But this is not this order of at 161 is not in consequence of that letter of 158. This appears to be independent.
Kindly see 158 once again.
158 is giving you a.
May I read for you also once again?
Yes.
The above customer of Brojopallo references complaint of Sri Aurobindo Pal of village so and so, a customer of Brojoballapur branch. The above customer of Brojoballapur branch has.
We are not on the incident. There is no ambiguity that there are two incidents. The incident is one and the same.
Yes.
There is no ambiguity on that. You need not emphasize that aspect. What we are saying is this letter of at 161, it is a punishment.
But this is simply says want to refrain from such activity in future. But the rules says, the bipartite settlement says warning is a punishment, is a minor in nature, though it's a minor in nature.
A warning or a censure, whatever it is.
Yes.
If it is inflicted by way of a punishment, it will be preceded by a show cause because it's a minor offense.
Yes.
It is treated as a minor allegation, minor misconduct.
Minor misconduct.
This is not referring to any show cause. This is just your officer in the bank who says, don't do this. We are warning you not to repeat this in future.
This is issued by
We have received
this by the branch manager.
We have
This is not issued by the branch manager,
No, this is by the chief manager.
the regional
Admin.
manager, the region office, from the regional office.
Whoever it is.
Yes.
But whether this is by way of a punishment,
But I must say, well, this is a punishment, in my respectful submission.
because it does not refer either to this confidential letter of 31/5/17
Or the inquiry report.
or the inquiry report.
But there is a confidential report which so caused me. There is an inquiry. Admittedly, there is an inquiry. And this is the order. This is the memo.
See, this 158 is perhaps a fact-finding inquiry which precedes issuance of a charge memo normally. That is why the authority, the senior manager admin, he has gone, he has looked into everything, has submitted a report. This report is submitted because the branch manager recommended disciplinary proceeding against you, which is apparent from paragraph 6 at page 160. Please read.
Yes, my lord. In the light of the above fact, I recommend for a appropriate action against Sri Pratul Kumar Nayak, and branch head should be instructed to be vigilant on the activity.
No, page 160, paragraph 6.
Page 160, my lord.
The branch manager has also.
The branch manager has also recommended disciplinary action against Sri Pratul Kumar Nayak.
So till this date, there is no disciplinary action. Till 5/8/2017, there is no disciplinary action whatsoever. There is only a recommendation for setting up a disciplinary action. This is of August 2017.
Yes,
In
for August.
December 2017, thereafter, without any proceeding or inquiry, this letter was issued, which you have not assailed.
I'm not assailed. I admit it. I'm not assailed.
So if it was a punishment, you would not have taken it lying down. This is a warning issued by some officer in your region who, instead of proceeding in a departmental inquiry, has said that don't do this in future. We have received such and such complaint. We are warning you to refrain from such activities in future. This is not a punishment of warning as contemplated in the bipartite settlement. This is after finding of guilt. Where is the finding? You read clause 8 of your bipartite settlement. What does it say? The opening line.
Found guilt of minor.
Yes, an employee found guilty of misconduct. There is no such finding. He says such and such allegations are being leveled. He does not resort to a proceeding. He said you are warned not to do such kind of activity in future. Although it is stigmatic, we can't say it is not stigmatic because it is in a way accepting it. But this is not as a result of any proceeding, and you have not challenged it.
I'm not challenged it.
Then
I'm not challenged it. But it's my case that it's a minor punishment. It is my case made out before the appellate authority, and also before this honorable court.
What the appellate authority said?
Appellate authority says that the chief manager has no authority to initiate any proceedings. But if I show to your lordship the order of the appellate.
So he has said it is not a punishment. If he did not have the authority, where is the question of you were on which post?
I'm also a head cashier.
So therefore, if he is not your disciplinary authority and he's issued such a letter, and it is not a penal order, then where is the question of double jeopardy?
No notification or rules was before your lordship regarding who is my departmental authority. No notifications or rules produced before this honorable court by the bank.
For what?
That who are my departmental disciplinary.
Why there is a finding?
What is the rules there?
How it makes a difference?
Because in the opposition, they have not stated anything.
Who is your disciplinary authority is clear from annexure page 95. He is your disciplinary authority because he has issued the charge memo.
The same, the chief manager.
Chief manager D&IR.
D&IR.
Yes.
And it was issued by the chief manager admin.
Admin. So he is not your disciplinary authority. That's why the appellate authority has said that he is not your disciplinary authority. It is not a penal order. But why you didn't challenge it, that we are unable to understand. You have chosen not to challenge it.
And the second point is regarding non-supply of documents.
So did the appellate authority say that this order will be of no consequence? 22/12/17 order.
my lord, may I show to your lordship the appellate?
And what is the date of the appellate authority's
Yes,
order?
my lord, I am sure to your lordship. Page 211.
What is the date of the order?
My lord. It's dated. This is served upon me on 21st January 2020. Starts from page 210.
And you filed your appeal when?
I filed my appeal. Madam, may I? I filed my appeal on so within time, my lord. Date is not given exactly, but it's within time. You can find the date.
See paragraph, the third paragraph at page 212. Please read it. There is no punishment.
That this was challenged before this honorable court. This order of the appellate authority.
Yes. The order, earlier order cannot be said to be a non-stigmatic order. It is a stigmatic order. Whoever this authority is, he has found the allegations to be substantiated because he says, don't repeat this in future. That means he has done it.
The charge sheet that is issued on 17 November 2018. Prior to that, that another one was charge sheet. But page 95 and page 115, the allegations are different.
No. It's the same allegation. We have seen that. B1, read B1 at page 95. What does it say? Please read. B1. The date is 15/12/2016. Now come to page 161.
Consider 95 column number E.
No, we will not. We will not. We will not. He is on the issue that whether that charge can be proceeded against twice. Why should we look at the other charges? Now 158. Now come to 159. The same date 15/12/2006 in the third line at paragraph 1. It is the same allegation. You said it is not the same. How you said, therefore we are saying here also it is 15/12/2016. Here also is 15/12.
One of the contention is there, allegation is there.
So therefore, if that has been taken into consideration, then how the entire thing will be vitiated? If that goes, then entire thing will be vitiated. Out of 4 charges, if 1 charge goes, then can you maintain the same quantum of punishment?
Not a domestic inquiry, it's a spot inquiry.
We have already observed this aspect. If you had left it to that, there would be no problem. But you have passed a stigma against him on 22/12/17.
Administrative capacity, chief manager administrative.
He will cast a stigma in administrative capacity.
And lots of discipline authority in this case.
This order is also challenged in the writ petition.
Yes.
Chief manager is the discipline.
22/12/17.
7/12/2017. No, my lord, this was not challenged. I should be candid. This was not challenged.
Chief manager.
No, but we are not convinced that this can be sustained in this way, even if he has not challenged. He cannot be punished twice. This is nothing short of a punishment. It is a warning. It is a warning issued by some authority. Why he has done it, in which capacity, that hardly matters. It is a warning referring to the same charge, which is charge B1 at page 95.
There's no special punishment is there. Just one.
We are making a prima facie observation. We are not convinced. You want to support your submission with reference to any judgment that in administrative capacity such an order can be issued. We are giving you an opportunity. We are prima facie not satisfied with your stand because it is issued by someone in an administrative capacity. Therefore, he can issue a warning, and thereafter, in a disciplinary proceeding, the same charge will be considered. Wonderful. What you cannot do directly, you can do indirectly. So therefore, if you want to rely on any judgment, we are giving you an opportunity. Prima facie, we are not satisfied. We will hear it on this point only. Take down. Yes.
But on 16, there may be a holiday because Ratha Jatra is that day.
What is there?
Ratha Jatra, Rath.
Thursday after that.
20.
My lord, I am appearing for the petitioner. On the earlier occasion, I have started my argument, but unfortunately, my lord, today I missed the brief.
Not today.
Not today, man. He is for the, Mr. Mohapatra is the learned advocate for the.
Not today.
I'm
Right.
ready with the matter. I can.
Not today is all right.
My
No, if you are having any difficulty tomorrow, we can have it some other day.
অসুবিধা নেই তো কাল জজ সাহেব ইউজ করছে ম্যাম গ্রেট Report number 12.
Hmm?
12.
What?
Mr. Pradeep Kaur, senior advocate, engaged in this matter. He is in court number 12, Your Lordship. Your Lordship, kindly pass over the matter.
Not today.
Mr. 14.
That I appear on behalf of the appellant. My lord, this matter was taken up for your lordship on 8 June 2026, when your lordships were pleased to observe this prima facie.
The prima facie observation,
My lord,
subject to whatever may.
my lord, the claim of the writ petitioners before the honorable single bench, my lord, will find at page 59 of the writ petition of the stay application, my lord.
Page
59 of the stay application.
The issue is whether there was a decision for grant of revised
My
allowances
lord.
or not.
My lord. The claim,
Prima facie, we have held that it appears that there is no such decision.
my lord.
Now the copy is served on them. So let them show, then we'll proceed.
That the appellant before your lordships not took a stand as if the recommendation of the seventh pay commission was accepted with regard to the payment of overtime allowances in 2024. That was the whole argument. Kindly lordship take their grounds of appeal, memo of appeal, because the lease decides on the point whether when the decision was taken. Your lordship's prima facie observation on the basis of that submission, as if the recommendation was accepted in 2024 and it was paid in 2024 after accepting the recommendation. That's why you are not entitled to the interest on that period.
Perhaps not.
That kindly takes the grounds
It was accepted in 17. But we have said that till 24, we do not.
That's the observation of the learned trial judge. But the kindly takes the grounds of appeal, page 4. Ground 4.
Yes.
Ground 5, ground number 5. For that, the Honorable Single Judge are in law and on fact and failed to appreciate that no right has been accrued in favor of the respondent writ petitioner under the Interest Act as the decision of the payment of overtime allowance as the revised rate as per 7th Pay Commission was not adopted by the corporation until 24th April 2024.
Yes. So therefore, we said, show from which document you are saying.
Yes, my lord. My lord is absolutely, I bow down. The observations just fell from your lordship that a decision was taken in 2017 or 18.
Yes.
That's the admitted fact. Kindly takes, my submission was just in brief. My endeavor would be to pursue your lordship that the decision was taken in 2017 and 18 to accept the recommendation of the seventh pay commission
In toto.
with respect to the overtime allowance also.
So let us see, let's come.
I'm just coming, just let me to summarize my points. That it saves your lordship time. That the decision though was taken and accepted in 2017 or 18, that my submission would be the revision of the pay scale, the DNS allowance and other allowances that was given effect from 2016 itself, from the date of effect of the seventh pay commission. Now the overtime allowance is part of the wages as per the definition of the Payment of Wages Act. So it's a statutory liability. It's not a contingent liability. It's an ascertained statutory liability which accrued right from the date when the decision to revise the pay scale was not accepted. That was
If we are considering correctly, your submission is that a separate stipulation is not required.
absolutely, but I bowed out.
It is inherent in wages.
Yeah, absolutely, but that is the observations of the courts also. Even the by way of executive instruction or office order, that cannot be curtailed.
Very well.
But this is also
So therefore, our prima facie observation then has no meaning today.
yes, I bowed out.
So therefore, if that is the situation, if we can see
Yes,
that no separate decision is required for granting allowances, the moment it is allowed, allowances becomes inherent.
yes.
Let us see.
But furthermore, they were also in dilemma because this point that whether to give effect from to give effect of the recommendation of the payment of for payment of overtime allowance with from 2017 or from 2016, that issue was taken by the union, of whom the petition is judgment, and there was a bipartite meetings and this issue was discussed. Now the company, it's a government company, your lordship knows, Security Printing. Earlier it was Mint. Earlier it was Mint Kolkata. Now after that, it became a corporation, Security Printing and Minting Corporation of India Limited. Now that company sought clarification for the department of the government of India. Government of India also the Ministry of Labor also gave some deliberations on the issue. Ultimately, they decided no, irrespective of that, it's governed by the Factories Act. So whatever is there in Section 15 of the Factories Act, you have to comply with that. So my submission would be that as per Section 59 and also as per definition of the Payment of Wages Act, I am entitled to the overtime allowance which was paid relatedly after my retirement.
Irrespective of any separate decision.
Absolutely. This is number one. Number two, another item, that is production incentive, that is also related to the wages. In my case, that's production incentive. That issue is not left to the authorities by the learned single judge.
We have one query here. If you once you say irrespective of the decision, that is in relation to the revised rate, because otherwise you are getting it as it is.
I was getting,
despite there being no decision for an enhancement as per their claim in respect of the allowances, it is not a case that you are not getting any allowances. You are getting allowances, but at the unrevised rate.
yes,
Allowance and incentive both.
absolutely both. Incentive, the moment it is accepted and it is given effect to revise the wages, I am entitled to get the overtime wages as per the revised rate as well as the production incentive.
So this you are relying upon the statutory provision.
Statutory provisions and some judge authorities. And the production incentive, that issue, a single judge was pleased to delegate the matter to the
will not
authorities.
be able to conclude right now.
I have
And
junior one or whispering.
somebody is appearing online.
No, my lord.
No. And the other thing is that this bench may not be available in the second half. So,
Lordship, skip it over as per your lordship's
so
convenience.
when should we keep it? You come, we will hear it. We have understood what you are trying to make out. We'll
Yes,
see if you can make it out. When?
as per your lordship's convenience. After 1 week or 2 week, whatever.
After 2 weeks, we'll keep it. The learned advocate for the
My lord, I'm humble request, my lord, kindly, my lord, I talked to my senior, my lord, he's coming, my lord, on 3 p.m., my lord. He's coming from Mudhumgram, my lord. From Mudhumgram, my lord. Mudhumgram, my lord. My lord, kindly, my lord, consider, my lord, kindly recall the order, my lord. He is appearing, my lord, on 3 p.m.
See, we are rising. You are still here. We are striking off that order. It is not today. Ask him to appear when it is taken up on Monday or Tuesday.
Monday or
Yes.
the Tuesday?
Today there will be no order. It is not today.
He's coming, my lord.
See, when you compel the court to such circumstances. For 13 years, this writ petition is pending, dismissed in default, and only adjournment thereafter.
Actually, my lord, this is
We are accommodating lawyers every day.
time, actually.
But sometime one has to look at the limits. This can't go on forever.
Kindly, my lord.
We told your learned advocate who mentioned in the morning that you please ask someone to come by 12. Still, nobody is here. Either you have a case, you don't have a case, you have to argue. This can't be kept pending for 13, 14 years only for adjournments and dismissal in default. Restoration. Not a single day any submission is made. So it is not today. Whoever has taken, which is that serial number?
Serial number 2, my lord.
2. बोल दो कोई ऑर्डर साइन कराने नहीं भेजा